Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings. The use of the death penalty as a bargaining chip in Innocence Cases. Claudia I. Salinas. 1. Playing a high-stakes game. Winning a case in court, like winning a game of poker, is not always a matter of holding good cards. Sometimes, it all comes down to playing a poor hand well. Even then, a skilled poker player needs to have chips to play. At a table full of poker players, it is no shock the player with the most chips in front of them sets the tone of the table and becomes the big stack bully. More bargaining chips allow the player to make more combinations of plays and bluffs. The player with the biggest stack of chips is able to bully the players with smaller stacks into folding, even if their cards are better, to avoid having to go all in. The small stacks are constantly playing on defense, waiting for pocket aces that will actually hold up against the big stack bully. In the criminal legal system, the stakes are always high. The big stack bully is the prosecution, the player with more resources, advantage, and backed by the might of the state or the federal government. The prosecution has the power to call or fold, to take the case to trial, or offer a deal. The small stacks invariably are the defendants, those players who come to the table at a tremendous disadvantage, and who are always all in. In the most serious cases, the prosecution can raise the stakes to the highest level by leveraging their most advantageous bargaining chip, the death penalty. While 70% of the world's countries have abolished the death penalty, also known as capital punishment, much of the United States continues to use it in its criminal legal proceedings. According to the Death Penalty Information Center, at least 190 people were exonerated prior to their fated execution date, after being wrongly convicted and sentenced to death in the United States. There is no way to tell how many of the 1,562 people who have been executed in the United States were actually innocent. As there are wrongful convictions still happening today, it is no surprise that most countries consider the death penalty a human rights issue. Among others, a frightening number of those exonerations were the product of official misconduct, perjury or false accusation, or false or fabricated confession, which often occurs simultaneously. When the prosecution brings a death penalty bargaining chip to the table, such a move changes the way a defendant plays their hand. This runs the risk of an innocent person pleading guilty to something they did not do, to fold their hand in the face of impossible stakes, guaranteeing a wrongful conviction. The California Innocence Project handled Marilyn Mulero and Reggie Cole's cases, where the prosecution used the big stack bully tactic. Marilyn Mulero felt coerced into signing a prepared confession, admitting to a murder she did not commit, which ultimately led to the imposition of the death sentence. Similarly, Reggie Cole, an exoneree who was wrongfully imprisoned, was subsequently accused of a prison murder while acting in self-defense, and confronted with the death penalty. These defendants were forced to make an unlikely combination of moves to overturn their convictions and avoid a death sentence. Fortunately, both Marilyn Mulero and Reggie Cole's winning pocket aces held up, and they were rightfully exonerated. All too often, however, others in similar situations do not beat the odds. 2. Marilyn Mulero, the player forced into an all-in situation. On May 12, 1992, two members of the Latin King street gang were fatally shot in Humboldt Park on Chicago's northwest side. The next day, Chicago police officers arrested Marilyn Mulero and Jackie Montanez. The police took them to the station to be interviewed separately. After the police denied legal representation, both women were each subjected to over 9 hours of questioning. Throughout her interrogation, Marilyn denied any involvement in the crime. However, it was not long before the detectives brought out their bargaining chips and told her she had two options. 1, confess to one of the murders, or 2, be prosecuted for both and die by lethal injection. Police began bluffing by telling Marilyn that Jackie had already confessed, implicating her in both murders. They told Marilyn she would never see her children again unless she confessed. The prosecution implied the death penalty was merely a placeholder, and they would never actually pursue capital punishment in a case where Latinos shot each other. Without having many bargaining chips of her own, Marilyn was forced to go all in. She signed a prepared statement by the prosecution, implicating herself in both murders. Without conducting any basic investigation into Marilyn's case, her attorney entered a blind plea of guilty on her behalf, which exposed her to the risk of a death sentence. Soon after, based on the jury's recommendation, Marilyn became the first woman to be sentenced to death in Illinois. Justin Brooks, founder of the California Innocence Project, traveled to Illinois and met with Marilyn in prison, where she adamantly maintained her innocence. While Justin could not be sure whether she was truly innocent of these murders, he was stunned at the reality that a defendant could be sentenced to death without a trial. As a result, he began litigating the case as a due process issue. In May of 1997, the Illinois Supreme Court ordered a new sentencing hearing after vacating Marilyn's death sentence. The result of the hearing led to Marilyn being resentenced to life in prison without the possibility of parole. Justin continued his investigation into Marilyn's case. Over time, he began to expose the weaknesses in the prosecution's cards. For example, defense investigators determined it was impossible for the prosecution's main eyewitness to have observed the alleged crime from their vantage point. Marilyn filed habeas petitions using this information, but the state and federal courts denied her claims. The United States Supreme Court ultimately denied certiorari. Justin went so far as to argue that the Illinois criminal legal system violated international human rights law by sentencing people to death without trials. However, the courts took no action based on those claims. In January 2017, Jackie came forward to admit she shot both men, affirming Marilyn's innocence. Meanwhile, an overwhelming amount of evidence revealing the misconduct by detectives involved in Marilyn's case surfaced. On August 9, 2022, the district attorney's office was forced to lay their weak cards down on the table and agreed to vacate Marilyn's conviction. Marilyn became the 190th person to be exonerated from death row in the United States. The prosecution's hand consisted of a false confession, a bad eyewitness identification, and instances of government misconduct. Marilyn's case is a perfect example of the prosecution using capital punishment to gain a better position throughout the entire criminal legal process. In other words, the prosecution used the death penalty in a manner similar to a high-stakes bluff. If you ask anyone other than Marilyn's original lawyer, they will agree that being sentenced to death on a plea bargain does not seem like much of a bargain at all, especially if you're innocent. 3. Reggie Cole, the player who made a good play given the circumstances. The case of Reggie Cole is another example of the state using the death penalty as a bargaining chip. On August 1, 1995, Reggie was sentenced to life in prison without the possibility of parole for a murder he did not commit. While serving his 25 to life sentence, Reggie stabbed another incarcerated person in self-defense during a prison fight. The prosecution decided to go all in by putting the death penalty on the table, given this would be Reggie's second murder conviction. The attorney representing Reggie had a mediocre hand and knew he would have to play intelligently to stand a chance against the big stack bully. Reggie's attorney knew he would have to make a combination of moves to win this hand, and he started looking into the integrity of Reggie's original conviction on the off chance that he could gain some bargaining power of his own. The attorney recognized the prosecution's discretion to charge Reggie with the death penalty under the special circumstances enumerated in sections 190.2 of the Penal Code, created some outs for his hand to get stronger by the river. In California, if a person is facing the death penalty for a prison murder, the defendant is allowed to challenge the original grounds of their incarceration. This extremely specific section of the California Penal Code was Reggie's out. Reggie's attorney, with the help of the California Innocence Project, discovered the prosecution was playing dirty with a hidden ace up their sleeve by withholding evidence. The prosecution knew their main eyewitness fabricated his testimony in Reggie's original trial. In April of 2009, the Superior Court judge vacated Reggie's original conviction based on withheld evidence and ineffective representation. Unfortunately, Reggie remained in prison for the murder committed in self-defense. Another year passed before his attorneys could successfully argue for Reggie to receive credit for his original time served under the vacated conviction. The district attorney's office was tilted from losing the original hand. They then filed new charges against Reggie for allegedly concealing a razor blade in his prison mattress. Fortunately, Reggie was acquitted on that charge and finally released on May 15, 2010. The importance of Reggie's case cannot be understated. Reggie's case exposed prosecutorial misconduct. The prosecution misplayed its hand by attempting to use the death penalty as a bargaining chip. The prosecution's strategy forced Reggie to go all in and play his hand for any possible outs due to the severity of the consequences. Luckily, in this all-in situation, Reggie made the stronger hand that proved his innocence, and he won his freedom after years of wrongful incarceration. 4. Changing the game. At the core of both of these cases is the startling fact that two innocent people risked being executed. Central to both cases is the combination of luck and chance. However, these cases are not unique. It is not uncommon for the prosecution to use the threat of execution as a strategy to better position the state in the game of the criminal legal system. Implementing this strategy gives the prosecution an unfair advantage. Indeed, it bleeds into many cases, even those cases reasonable people would not consider death-worthy. In 2021, the Pew Research Center conducted a study to better understand America's views of the death penalty. The study concluded that 60% of adults in the United States favor the death penalty for people convicted of murder. 27% of adults strongly favor it. Proponents of the death penalty often argue the simple threat of the death penalty deters criminals from killing or committing other heinous acts. In theory, prosecutors should only be threatening the death penalty in the worst possible cases. However, in practice, and as applied to individual cases, the threat of the death penalty is up to the subjective determination of the prosecutor, and does not aim to punish the worst of the worst. For example, in California, Penal Code Section 190.2 lists 22 of the special circumstances that could trigger a death sentence in a murder case. Some of the circumstances include murders that are carried out for financial gain, in efforts to avoid or prevent lawful arrest, for purposes of preventing testimony, by means of lying in wait, or in the commission of one of 12 enumerated felonies. The special circumstances are broad enough to encompass creative, reasonable arguments for almost any murder to fall within the scope of capital sentencing. Therefore, the copious number of special circumstances creates more opportunities for prosecutors to use this bargaining power. The very possibility of the death penalty allows prosecutors to play their advantageous bargaining chip. This strategy results in the overcharging and bullying of defendants to negotiate a lesser sentence, which does not result in death. The way the prosecutors use the death penalty in Marilyn and Reggie's cases, and many like them, goes against the two premises Judge Carney highlighted in Jones v. Chappell. 1. That the government does not seek death arbitrarily, but instead must only do so when it furthers the interests of society, and 2. That the death penalty must be applied consistently and reliably to similarly situated cases and defendants, so that the system and society can be sure that death is the appropriate punishment for any specific case. The very act of negotiating down from a more severe punishment to a lesser punishment in exchange for waiving rights is coercive on its face. That issue is further compounded when the possibility of death is on the table. Indeed, defendants may not ordinarily seek pleading to a sentence of life without parole. However, when faced with the possibility of the death penalty, defendants are more inclined to accept pleas that would otherwise be rejected. The difference is a matter of life and death. There are concerns that the threat of the death penalty will coerce defendants who are not death-worthy. This issue includes those who may be innocent, but plead guilty in an effort to spare their life. Consequently, the death penalty is not used as intended to further the interest of society, deterring or punishing the serious or heinous acts, but rather is used by prosecutors as bargaining power to guarantee convictions. The issue of innocence within the death penalty debate gained significant attention in 2014 after the National Academy of Sciences reported at least 4.1% of defendants on death row are innocent. The report also suggests the number of innocent people is likely more than double the number of those actually exonerated and freed from death row. With prosecutors wielding such high bargaining power, it is arguably inevitable that innocent people will continue to be convicted and sentenced to death for crimes they did not commit. Shockingly, even after NAS released the report, the Pew Research Center found that only 78% of people in the United States believe some risk of wrongful conviction exists. Additionally, only 21% of adults think adequate safeguards are currently in place to prevent wrongful convictions. 30% of death penalty supporters believe adequate safeguards exist to spare innocent people from execution. Given that the error rate of the death penalty is greater than 0, there are no effective safeguards that exist. State legislators must implement more safeguards to prevent prosecutor strategy from resulting in the murder of innocent people. States should consider eliminating, or at the very least clarifying, many of the special circumstances enumerated within the respective death penalty sentencing schemes. As currently enumerated, these over-encompassing sentencing schemes allow prosecutors to play more aces than a deck typically has by choosing which murder cases they want to impose the death penalty on. The death penalty is intended to punish the worst of the worst criminals. But, as California Governor Gavin Newsom stated in his executive order, the punishment too often falls on the young, especially youth of color, disabled, mentally ill, and on those raised in abusive environments and extreme poverty. It is difficult to conceptualize that the sentencing scheme accurately narrows down these marginalized groups as the worst of the worst. A prosecutor should be forced to play with their cards face up. This means the intention of utilizing the death penalty should be abundantly clear from the beginning, when the defendant is charged with a capital crime. Specifically, prosecutors should be able to indicate and support with solid evidence the extreme circumstances that would elevate a first-degree murder to a capital murder. Their decision to pursue the death penalty should be reviewed with strict scrutiny by an independent agency. This objective review would help assist in regulating the prosecutors who intentionally overcharge in hopes of coercing defendants to give up their constitutional rights to a fair trial or into deals they normally would not have made, but for death being on the table. Independent review would add an additional protection to ensure no racial or socioeconomic disparities in the prosecutor's decision exist. Finally, prosecutors should only be allowed to play in the game if they are able to abide by the table rules. A death sentence should only be imposed when a prosecutor can unequivocally prove, beyond a reasonable doubt, that the defendant committed a capital offense. While this is the legal standard prosecutors are held to, criminal defense attorneys would argue that it is not uncommon for the prosecution to have shadows of doubt in their cases, but still be able to manipulate the emotions of the jurors to secure convictions, consequently, against innocent people. At the very least, and under no circumstances, should there ever be death sentences imposed without a trial or on a plea deal. 5. Eliminate the bargaining chip. Many defense advocates would agree getting convicted of a crime when the prosecution has all the bargaining chips is much easier than going against all odds to overturn a conviction and prove innocence once a conviction is final. Marilyn and Reggie's cases demonstrate the imbalance of bargaining power in the criminal legal system, favoring the prosecution. The consequences of this imbalance are deadly and irreversible. Given the harrowing stories about the wrongful convictions and misuse of the death penalty, at some point, the poker floor manager needs to eliminate the bargaining chip from the international game altogether, so that the others in the game can have a shot at winning.